All right. So we are proceeding with today's class. James AAPOREKUU, member of the Chartered Institute of Arbitrators, and today I'm going to take you through what mediation is, what it entails to be in mediation process or to invoke the mediation process. Now, one may ask, what is a mediation or what is mediation? Before we delve into what constitutes or what amounts to mediation, first of all, we must also ask ourselves, it is only conflict that can lead party to a particular situation or to a situation of solving a problem, okay? So mediation is one of the ADR mechanisms or ways of solving a dispute. When we talk about ADR, we are saying that it is an alternative way of solving dispute. And dispute can only be resolved or remedied whenever there is a conflict between two or more persons, okay? So first of all, we need to understand what conflict is. So in our daily lives, life comprises of several differences, individual differences, we have cultural differences, we have geographical differences, and all these kind of things. So some of these things leads to conflict. Why does it lead to conflict? And what way does it lead to conflict? Because what you may be requiring from one party may not be the same way the person may receive your message or information. So that leads to conflict between these parties. A conflict can also arise through war, but those kind of wars, they are not subject to mediation. ADR is not, when it comes to criminal matters, even war, most of war issues are revolving around international criminal law and those kind of things. Mediation as one of the ways of solving dispute out of the court system is not tenable, or when it comes to issues of conflict or which has to do with criminal law. So conflict, once it is unresolved, once it arises between two or more parties, that is where it needs to be resolved without invoking the court's jurisdiction. So we're saying that it is an alternative. Mediation is an alternative to using the court. If you take ADR, for instance, I would like to explain ADR a little bit before we take one of the mechanisms that falls under ADR, okay, in order for each and every one of us to appreciate the concept of mediation very well. Now, we say ADR, Alternative Dispute Resolution. ADR, its acronym or shortcut, worldwide known, everybody knows that. We're saying that when we talk about ADR, it consists of arbitration, it consists of mediation, and to some extent, we bring conciliation. Conciliation and mediation, to some extent, they have a very close relation. Okay, so mediation is one of the ways in which we can resolve dispute without going to the court, and we can resolve dispute whenever one or two parties disagrees amongst themselves. All right. Now, what then is mediation? You're saying that mediation is a voluntary, it's a party-centered and structured negotiation process where a neutral third party assists the parties in amicably resolving their dispute. So having already said that mediation is one way of resolving dispute, it is when two or more parties amongst themselves, they disagreeing that it is A, this person say it is B, and they decided that no, we cannot solve this by ourselves. Let's bring a third party to solve this. That third party must be an impartial third party, okay, in order to resolve the differences, okay, between the parties that will approach the person. And this person we are saying, we are talking about here, when it comes to the mediation process, we say that person is the mediator. So in mediation process, we have the mediator who facilitates and evaluates the problems that the parties come forward with. So as a mediator, your duty is only to facilitate the process. You don't have a decision-making power. You cannot make a decision to bind the parties. That is why, as you'll be moving along, I'll bring to your notice that when we talk about mediation, okay, mediation is it is an assisted, negotiation. When you talk about negotiations, it is even to some extent it's part of the ADR mechanisms, but it's not one of the real ones that we always talk about. Negotiation is when, in our daily life, we negotiate without even knowing. Sometimes you are going to buy water from the shop. The person is saying that it is maybe 7,000 rand franc. and you try to negotiate with the person, oh, I'll give you this amount of money, or can you reduce it? What is the convincing power that you have to tell the person to reduce it to the price that you want to buy? These processes we term it as negotiations. And now we are using negotiations in the context of mediation. We are saying that mediation is an assisted negotiations. Why are we saying that? We say it is an assisted negotiation because over here, the mediators have already said, don't have a decision-making power. It's only to evaluate and assist the parties to come to a conclusion, to resolve a dispute amongst them. So in so doing, it is still the parties amongst themselves that they have an issue, who are going to resolve the issue amongst themselves, okay? They are going to negotiate, but this time around, they have somebody standing in between them to facilitate the process in order to avoid any chaos in the process of doing that. So that is why we use the term assisted negotiations in the context of mediation, okay? So now we are moving forward. We've already known what mediation is. This course is going to be examined, so I'll urge each and every one of you, if you don't understand anything at any point in time, just let me know, and we will talk about that, and then we proceed. Also, everything I say here, it is going to constitute a higher part of the examination before certificates are issued to participants. Now, when we talk about mediation, we have different stages in the process of invoking a mediation. So what are these stages that we are talking about? We say that we have four major processes. We have the introduction and opening statement stage. Okay, we have the understanding the parties and their issues, problem solving, and closing remarks or closing stage of the mediation. Now let me take it one after the other. When you talk about introduction and opening statement in the context of mediation, okay, in applying it in the mediation stages. At this stage, as a mediator, that is where the parties have already approached you. They've given you a prior knowledge of what they want you to assist them to resolve. Now, let's put it in a practical context. They've come to your office. It is from the stages that you welcome the parties who are in dispute, okay? We welcome them and then tell them that, thank you so much for choosing me, and I am arbitrator ABCD. I've been in practice for this number of years, and I've even done ABCD. I'm a certified mediator from the Institute of ABCD. These are some of the introductory remarks that mediation comes with. It is a max, as we are all learning. As a lawyer, you cannot even receive a client without taking the client through some introductory remarks. So in mediation, too, we have the same thing. We have similar thing. Let me put it that way. In mediation, we have similar things. So you have to tell the parties who have appeared before you to assist them resolve their issues that you are ABCD, and this is how the process is going to be invoked. I'm going to use this method. And in the process of me mediating, I can use a separate meeting. What is a separate meeting that we are talking about? We are saying a separate meeting is a caucus. Okay, when you say caucus, it's just like two parties have approached you. For instance, a husband and wife, they have issues and they want you to mediate. So as a mediator, now you've gotten to a point that all the parties are taking a stand. This one doesn't want to say this one doesn't want to say this. You are stuck. So you have to go in caucus. The caucus is a separate meeting. You explain all this to them, the processes involved, the rules involved. During the mediation, you don't have to put off your phone. When one party is speaking, you don't have to interrupt with the other. I'll give you the equal opportunity to also rebut once A, B, C, D is done, or once party A is done. This is the stage one, the introductory, opening statement, and all those kind of things. Are you getting it? I was on caucus. Caucus is when you've stuck in the process. The parties don't want to reveal the real truth in the situation. So you pull one party from the meeting, go to a separate meeting, and ask the person questions. Or if you see that one party in the meeting, in the mediation process, has broken down because of how passionate he is about the information that he's revealing, you can excuse the other party. Take the one who is down to a different room, try to console him or her, and encourage him to speak out so that you get the real information. That is introduction. That is the opening statement. Now moving on, understanding the parties. What is the real issue? Why did the parties choose you as a mediator? So over here, what's the underlying cause? The underlying cause basically has to do with what actually triggered the issue between the parties. So it is only after you've listened, okay, to the parties, the listening to the parties who comes under the opening statement after you've done just listening to the parties. Now, understanding the parties is when you've listened to them, okay, and say that no, the underlying cause in this particular problem is coming from maybe the man not giving the woman, pocket money or money to cook for the family, all those kind of things. So that is the underlying cause that you're going to get from this particular issue. Now, third point is problem solving. What is problem solving? When we talk about problem solving, the problem solving has to do with they have brought the underlying issues. The issue is that my husband that do not come home early whenever he closes from work. What is the cause? The cause is that the husband is saying that my wife, when it comes home, she always gives me troubles. So what is the underlying cause? Why does she always give you troubles? So you try to fish out. And then you ask the parties, what are the ways and means you want to resolve your issue. If you ask the parties, now I've understood your issues. How do you want us to resolve this particular issue? Okay, don't try to suggest questions or answers. Okay, don't try to suggest answers to the parties who have appeared before you when you get to the problem solving stage, because you are a mediator and they count on you so much. They know that you know so much. So if you trigger the problem solving options, for instance, if you say that no, I think we have to always come home early because ABCD, you are suggesting answers or solutions to their problem. They'll go by yours without brainstorming. So when you get to this stage, the third stage, you always have to let the parties brainstorm, come out with their own options, the options that they think it is best. So after that, you can come with further questions to ask that, don't you think if you do ABCD, it will help you resolve this issue? After they've brainstormed and come with out with their ways and means they think they can resolve the problem. Okay, so that is it. As a mediator, you don't suggest answers to the parties who have appeared before you. You just evaluate, facilitate, and after they've brainstormed, if the need be, that's why you also suggest that don't you take, you can do A, B, C, D. Now moving on to the closing aspect. The closing aspect basically has to do with when you've gone through all these processes. Okay, when you go to all these processes, you have to come to an agreement. You call it the mediation agreement. Sometimes it is called the memorandum of mediation and all those kind of things. It is where the parties come to an agreement amongst themselves that from A, B, C, D, I'll be coming to home very, very early, and then the wife also agrees that yes, I'll be cooking the best food for you. That is why I don't cook the best food for you. That's why I don't come home early. Those you like going out to eat and those kind of things. So they now agree among themselves that if this agreement that they've come to, okay, fails, they are going to come back to mediation to resolve the issue, or they'll prefer to go to court and resolve the issue. All right, so that is the closing aspect of mediation. Please, I can see a hand up. Do you have a question?
Oh, yes, I have a question.
Okay.
Oh, you recently mentioned about the introduction and opening statement, but I want to know more about the opening statement. Is there any formal way that you can use just to open the discussion, or just someone as he is talented or in some way is encouraged, or the situation requires for him, he introduce as he wish?
Okay. Okay. Thank you so much for the question. Yes, so when we talk about the opening statement, as I've already said, introduction and opening statement, it is combined. So when we talk about opening statement, it is where you introduce yourself as an arbitrator and you bring to bear, okay, the processes involved in this whole mediation process. You tell them this mediation that you are going to enter into, the mediation process, it is confidential. All these things are opening statements. As to how the mediator does it, it is left to him, but you must do it. It must come under the introduction and opening statement section. Okay, you have to tell the parties that You know, if you want to even ease yourself, this is the way to the place. This is how it is going to be. All of you are not going to be speaking at the same time. If you want to speak, I'll give you the equal opportunity once party A is done. This one, you don't have a laid down procedure, but it comes under the first process that every mediator has to do. I hope I've answered your question.
Yes, sir. Thank you.
You are most welcome. You are most welcome. Okay, so we are proceeding. I think I'm done with the closing section or the closing stage. And so when it comes to mediation, these are the four major or the basic things that every mediator must use in order to resolve a dispute amicably and professionally. Thank you so much this far. Now, what are the types of mediation? You hear mediation day in and day out, and we've defined mediation. So we have two basic types of mediation, okay? We have the one that is referred, okay, by the court, where there's a legal tussle, or there's a case between two parties. All right, it is already in court. They've initiated the legal proceedings, okay? And now, throughout the processes, the court processes, the judge has examined the case and seen that no, this issue can be resolved through mediation. So let me refer the parties to go to mediation. The court has that jurisdiction. You know, we are talking about international issues over here. I can't relent, or I can't restrict myself to only one particular country. But I must tell you on fact that when it comes to AVRO and the mediation, we have our domestic laws covering this. It's a general principle. The court can do this. The parties on their own can make application to the court, and the court can do that. The court must act on their application if the court deems it reasonable to grant the application to go on to mediation, okay, when the case have already been in court. So that is the first part of, or the first type of mediation that we have. You have the court referred mediation, and you have the private mediation. Private mediation has to do with the situation where the parties amongst themselves have agreed that let's approach A, B, C, D, or let's approach this mediator to resolve, to stand in our middle to help us resolve our situation or our issue. So that is the private mediation. So we have two basic types of mediation. We have courts referred to mediation, and we have the private mediation. Private one, as a general principle, it is the parties, they themselves, that initiate the processes. They don't need the intervention of the court to refer them to any place. They do that on their own accord. Yes, please, Pascal, you've raised your hand once again.
Thank you, sir. I have a question on the court-deferred mediation. And my
What you have a
question
question
is,
on?
in normal circumstance, mediation, but court-deferred mediation.
Okay.
Yeah, in normal circumstance, mediation must be voluntary, and it must be just the parties initiated means of settling their disputes. Then the question is, why judge has just to remind the parties that they should follow the mediation process? Why they didn't initiate that process? Isn't it undermining the legal capacity or the mind capacity of the parties to show them that they should have thought about it? Why they did not?
Oh, okay, okay. I've gotten your question. Thank you so much. Now, to begin with, I honestly do not think that the court referring parties to mediation undermines the capacity that parties have to initiate a court proceedings. Why? Why? In the sense that once you appear before the court have the jurisdiction to direct you as to how to come to a conclusion or to resolve the issue that you've come with to the court. Now, for instance, you may have a marriage issue, okay, that have been pending in court for years. But whenever the parties appear before the court, you could see their conduct, by what both parties are saying, that they still have that love amongst themselves. Okay, but it may be something small that triggered that processes for them to go straight forward to initiate legal proceedings without going to arbitration. So the court, the court, okay, on its own accord, can say that I'll prefer you guys, to go to arbitration, okay, try to resolve this issue. If it fails, you still have to go to court. At the end of the day, the mediator will give a report and we must serve it on the court. If it fails, the court proceedings proceed. If it doesn't, the decision that the parties have arrived at the mediation is adopted as a judgment by the court that referred the case to the mediation. Okay, so that is how it is operated. It doesn't undermine the capacity that parties have to initiate court proceedings. Okay, thank you. I've seen another hand. Please, what do you have to say?
Sir, before anyone can ask, just I'm having some concerns about this issue of court-referred mediation. We see in some competencies, legal provisions provide for the reference to the mediation as prerequisite for bringing a case, a suit before the court. Don't you think that it is unfair?
Okay. Now, if in any case, okay, if in any case there's a provision that says that if ABCD happens, you must resolve it through mediation before the court, that would be an exception to the general rule that parties, can be referred to mediation or the other way around. Okay, so that's why I'm saying that when it comes to mediation, okay, this person just called me to distract me. When it comes to mediation, the courts have that power to refer the parties to go on mediation. I don't know. Please, can you ask the question again? When I was speaking, somebody called me, so I got distracted. Can ask the question again? Ask the question again. I'm really sorry.
Yes, sir. I think you've got the question since you were
Pardon? Can you
please, can you be audible? Can you be audible?
Sorry.
Can you raise your voice?
Yes.
I'm listening.
Okay, I am asking, and I have understood that you've got my question. And the question is, in some legal provisions, you see somewhere written, in order to bring the case before the court, you must first refer to the mediation committee.
Okay. Then, I get it. Okay. Thank you for the clarification. Yes, as I've already said, in that circumstance, that would be an exception to the general rule that, as I've already said, that would be an exception. For instance, if you have a contract and within the contract, one of the terms of the clause is that whenever there's a dispute amongst us, we have to first of all initiate a mediation process. That would be an exception to the general rule that I'm talking about. Okay, so thank you. Please, can I proceed? Or there's a different question I'll have to address. I think somebody else raised his or her hand. Okay. All right, then I'm proceeding. So we are done with types of mediation. We have court referred to and private mediation. Now moving on, one may ask, what are the general or what are the key features when it comes to mediation? Okay, you can't study mediation without knowing the key features or the ethics, the characteristics of mediation. First of all, one of them is that mediation is voluntary. Mediation is voluntary. Why voluntary? Mediation is voluntary because it is the parties themselves who have agreed that we want to approach mediator ABCD to help us resolve our situation or our differences. So it is voluntary. The parties may decide to go to mediation or may say that no, let's use a different, let's go to arbitration. okay, or let's go to the court. So it is a voluntary process. Even if the court has referred the case for the mediation, or if mediation is required under a contract, as I already said, or a statute, the decision to settle and the terms of settlement always rests with the parties. So as I've already said, even if the court refers and the parties think that no, even though the referral at the end of the day is going to be endorsed by the court, we don't want it, the court to agree with the parties. Okay. And as I've already said, if it's provided for by a contract, it is still the parties who are going to provide that mediation is ABCD, ABCD. Okay. Unless in situations where they've said that you have to first of all invoke mediation before the legal process itself. That will be the exception to the fact that some of these things are voluntary. Secondly, mediation is a party-centered negotiation process. So it's a party-centered negotiation process because we said that in my introductory remark, I said that mediation is a assisted negotiation. The mediator is just going to stand in the middle and let the parties battle it out. They're still going to say the same things that they will have said to like a face-to-face negotiation, but this one around, there's a third party in between them to make sure that there's no chaos, to make sure that the parties don't fight amongst themselves, and to make sure that it is resolved amicably. So that would be the mediation is a party center. It is a party center in the sense also that what the parties want it to be is how they are going to do it. It is focused on what they want at the end of the day. You can still go to court at the end of the day, a decision will come, but the decision will not resolve the problem between the parties. That is a very good aspect of mediation. So it's a party-centered. You can go to court, the court will give a decision. The decision may not satisfy all the parties. I've seen a situation where the court have rendered judgment, and the one who even is, the court says the person's a winner, the party's a winner, appealed, and the court said he lose the case, also appealed. That means that that particular process is not a party-centered process. It's just an application of laid down rules, and that may not satisfy the parties. That's why I'm saying that mediation is a party-centered negotiation process. Now, mediation is a structured negotiation, okay? Though the mediation process is informal, which means that it is not governed by the rules of evidence and formal rules of procedure, it is not casual process. So it is not a casual process because I've already said that in negotiations, the mediator tells those who have the parties who have approached before him or her that these are the laid down procedures. When a party is talking, you don't have to talk. There's confidentiality in mediation. What we are going to discuss over here, you can't use it against any other party in a competent court of jurisdiction if this mediation fails. So these are some of the processes that comes with mediation as a structured way of negotiation process in the mediation process, So that would be that. Moving on. So mediation is, in essence, is an assisted negotiation. I think I've spoken about this several, and the mediation is conducted by a neutral third party. Okay, it is conducted by a neutral third party. Martin, I'll come to you. So why are we saying that it's conducted by a neutral third party? The parties sat down and realized that mediator ABCD is the best person to resolve our issue. When the parties approaches you, or when the party approaches you, okay, you don't have to suggest answers or make decisions for them. As a third party, you don't have to stand with one party and then leave the other alone. You don't have to try to praise the other and then let the other person feel left alone. Okay, so you only have to facilitate and evaluate whatsoever thing the parties say to you, and leave it up to the parties to make their own decision, and not you to make a decision for them, or to show some sort of impartiality amongst the parties who have appeared before you. Okay, so that is what you're saying, that there's a neutral third party over here to help them resolve the issue. Okay, so Martin, please, what do you have to say? You have a question? Okay, I would like to make it this way, please. If you have a question, just put it down. At the end of the discussion, you raise your question and then I answer you, so that we can beat time. I just left you some few slides to go. So I'm proceeding. Mediation is a private process. Okay, it is a private process because it is not open to the public as compared to the court system. So mediation, they agree A, B, C, D. They go and meet at a place confidentially. No one will know of the fact that no, we've gone to mediation and it failed. No one will know of the fact that I even have issues with this person and we've gone to court. It is a private issue. It's a private process. That's why I say that it is highly confidential. Anything you say at mediation, you don't have to reveal it to anybody who wasn't in the mediation process. If you do that, you're acting contrary to the laid down procedures, even though it is different from the court. You're saying that we have casual ways and means of solving it. They also have their own procedures. So mediation is highly private, and parties to mediation cannot disclose any information to a third party without the prior consent of the other party. So it is highly confidential. Okay. Now, having spoken about all these features, it is confidential, it is party-centered, it is private, and all those kind of things. What are the importance of one going to mediation? What are the merits? What are the merits? What does it merit one to go to a mediation? First of all, you're saying that the parties have control over the mediation in terms of, its scope, the terms of reference, the issues to raise, and all those kind of things. You can go to court and the court will say that, hey, your problem you've brought before the court, you can only raise these issues. Or we think that these are the issues that you can talk about. In mediation, that is not the case. You have the ample time to raise the number of issues that you want. You have the right to decide whether to settle or not, and the terms of settlement. In court, you cannot decide the terms of settlement of a dispute. Who will give you that opportunity? We're also saying that it's participative. Mediation is participative because at the end of the day, parties are going to be given enough time to express their opinion. Okay. And you can go to court, and then the court sometimes depend on the system. Most of the times, with the common law systems, we always have the opportunity. For instance, when I was in Ghana, go to the court, those kind of things. You give the time to speak most of the time. But in most civil law countries, most of these civil cases and those kind of things, you don't even need to be in court. They don't really. For instance, let me use the rundown system. Before you institute or initiate a court proceedings, okay, you want to go to court, you have to file everything online. And when you file online, your pleadings or everything, evidence, everything is put in the online system. And before you go to court, the judge already know the evidences, everything already. That's the civil law system, So the judge at the end of the day need not to hear from you again, because you're putting in everything that he needs to hear or he needs to see. So it's just calling you to clarify or ask some confrontation questions if there's the need to do that. So, but in mediation, you have the time, you are face to face, you express yourself and all those kind of things. So the procedure also is voluntary. I've spoken about voluntary already. When the party decide to do what they want, to opt out or to stay in the stage, wherever they get to. And the procedure is speedy, efficient, and economical. You don't need to spend much time or much money going to mediation. No, it's very simple. And it's very efficient. It can be resolved within some small time. Not like the court system where it can take decades for a case to still be in court, And it is also a process conducted in informal, cordial, and then conducive environment. Mediation is a fair process. So it is also confidential. These are some of the merits that if you resort to mediation, you benefit, as compared to the court. These are some of the demerits. Demerit, it is not compulsory. So you're saying that it's not compulsory. A party may decide even not to go frustrate the process, but it will have been done easily when it goes to mediation. Okay, these are some of the challenges that comes with mediation. So all parties must agree to a resolution. As a result, it's not guaranteed. So it can be difficult for parties to also come to an agreement, because one party will try to drag the process, and all those kind of unnecessary delays just to buy time, because that person doesn't have any case, So these are some of the demerits or disadvantages when it comes to mediation. This list is not exhaustive, so you can count on and on, but these are some of the things that we're going to limit ourselves in terms of the conducting of the examination. Okay. What then is the comparison, okay, between judicial or the court system and mediation? This is very important, because most of the time people don't know this. How do you compare mediation with, the court system? So judicial process is an adjudicatory process where a third party, the judge or other authority, decides the outcome. But in mediation, it's a negotiation process and not an adjudicatory process. So the mediator facilitates the process Parties participate directly in the resolution of their dispute and decide the terms of settlement. So at the end of the day, it is not adjudicatory as compared to the court system, even though it is an adjudicatory process, but the parties determines the terms of the settlement of the dispute, even not even the mediator, So that is the nice aspect of mediation. Secondly, procedure and decision are governed, restricted, and controlled by the provisions of the relevant statutes when it comes to the court system. So that's why I already said that sometimes go to court, the court have made a decision, but the issue between the parties is not resolved, it's not solved, it still persists because they are applying restricted rules, laid down procedures. The law says, but that may not lead to the resolution of the problem. And sometimes it causes a whole lot of confusion. Why don't you go to mediation? So that's why I'm saying that mediation process and settlements are not controlled, governed, or restricted by statutory provisions, thereby allowing freedom and flexibility. It's a flexible process and freedom to decide what to do and what not to do. So it's a very nice way of resolving this instead of going to court. A decision is binding on the parties, can you imagine? Even though it is also binding on the parties in settlement, when settlement is reached in in mediation, only if parties arrive at a mutually acceptable agreement. So in a court decision, a decision can be reached without favoring any of the parties. So both parties will appeal. But in mediation, when they say the decision is binding, that means the parties themselves, they've accepted mutually that this decision satisfies all of us and it binds us. So it's a win-win situation, not like the court system where one party wins, the other party loses. In mediation, it's a win-win situation. Now, proceeding, we are saying that adversarial in nature as focus is past events and determination of rights and liabilities of parties. That's the court system. But when it comes to the mediation system, it's collaborative in nature as focus on the present and the future and resolution of disputes by mutual agreement of the parties, respective of rights and liabilities. So this one, they determine rights and liabilities and past events. This one, it is more of the future events going forward, and they agree on those terms of settlement mutually, okay? And then they don't care about rights and liabilities. No. Fifth point, personal appearance or active participation of parties is not always required. So personal appearance and active participation of the parties are required in mediation. So in mediation, you must appear yourself to freely and flexibly express yourself for the dispute to be resolved. Sometimes you have lawyers appearing, but you must come with your lawyer, because at the end of the day, the lawyer is not the one going to narrate the case to the mediator to assist you resolve it. Okay. So in the court system, the sixth point, the court system, a formal proceeding held in public and follows strict procedural stages. Whereas in mediation is a non-judicial and informal proceeding held in private with flexible procedure stages. So this one is private, this one is public. We've spoken about this. Decision is appealable. So settlement is final and it is not appealable in the mediation process once the parties have mutually agreed on that particular terms of reference or terms of settlement. Okay. So the essence of mediation, I think you're getting close to what is the essence of mediation. So mediation provides individual the opportunity to resolve dispute quickly before they result in legal actions. So you can see that why they say that mediation, ADR, the best lawyer always try to restrict him or herself to ADR because you save time, you save energy, you save a whole lot. And at the end of the day, you get you get the money you want without going to court, adjournments, unnecessary adjournments, this person is sick, your honor, my lord, Why not go to mediation? It's a very simple way and quick way of resolving dispute. It is only if it fails that you now resort to the court process, by then you know that all of you've agreed to waste your time in court. Sorry to say this. You've agreed to waste your time in court because it's not going to end anytime soon. Because judgment to come, one party will decide to appeal. Okay. The other point is that in mediation, we go to mediation because it resolves disputes inexpensively. Mediation is very cheap. It's not expensive. You can come to an agreement without saying, my lord, I pray for this cost, to be borne, it should be borne by the defendant hearing. No. We don't do that in mediation, So in mediation is very, 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 very cheap and affordable. Everybody can afford mediation. Not like even arbitration, which is one of the mechanisms in ADR. The arbitration is very expensive. If you're poor, if you're broke, my brother, don't go to arbitration. But there are some issues that must be resolved by arbitration, not even mediation, So just know your level. So the third point is that it's like mediation maintains personal and professional relationship. You can imagine people going to court, they were so close to each other. At the end of the day, once you drag somebody to court, automatically in most African countries, the other party becomes the enemy of the one who sent him or her to court. That is very, very common in our societies. Once you take somebody to court, you are deemed as you're an enemy. This man, no. In mediation, both of you are there. You're even smiling to each other. The mediator will help you smile to each other. At the end of the day, you hug each other. You go your way. Not the court where the judge will say that try to do no. Don't even go to court. I'll not urge you to go to court from the word go. Try to use some of these mechanisms before invoking the court process. So it's very professional. It leads the parties to still remain in their professional relationship without any distraction. Okay, going forward. The last but one point is that mediation resolves dispute with more satisfying result than what a court may order. As I've said this severally, the parties in mediation will say that we want A, B, C, D, and the one will say that why do you want this? The one will explain to him, oh, I want it to be done because if it's done this way, I'll benefit, you also benefit. But in court, both of you, okay, the plaintiff or the defendant don't have the opportunity to negotiate with each other in front of a judge that they said, no, you don't have that opportunity. So that's why I'm saying that it's so satisfying. In the process of the parties in mediation, negotiating among themselves that let's do this, to have the both of us, in front of the mediator. In court, you don't do this. The judge, the lawyer will just represent you in court and say, my client wants ABC, my client says the other party will say, do you have any cross-examination? Do this. After that, you don't have anything to say whether the decision that will be coming out is satisfying. It's satisfactory to both of you or not. No, it may be satisfactory to one party and the other not. And that's why the other will appeal. Or it may be satisfactory to one, not totally. And both of them will apply. That means court decisions are not only satisfactory, but they only have to make a decision. A decision can be made but not satisfactory. But mediation, once a decision is made, it means that all the parties are satisfied with the said decision and it binds them. Okay? The last point is that it is actively participative. The parties participate actively, okay, in solving their own conflict. And what then is conflict? I've already defined conflict in our first slide also, that conflict is when we are individuals and we have individual differences. We have a very different ways and means of doing things. And my way of doing it may not be your way. And that is why we try to conflict each other. And we try to resolve these conflict issues or conflict by invoking the court process, by going to ADR, that's mediation mechanisms, or arbitration and what have you. So the parties participate actively in resolving their own conflict. Not like the court system, what judge is going to give you that ample time that say no, you'll be sometimes be speaking and the judge will be like, counsel, what your client saying, how relevant is it to this case? So that is the aspect of the court system as compared to mediation process. So ladies and gentlemen, we've gone through a lot, we've gone through a lot, and this is how far the Lord has brought us. This is the end of today's class, that's mediation, and we are so much glad for having majority of you here joining. I'm pretty sure that most of the people who missed this live session will go to YouTube or Facebook, to follow the discussion to as well, so that you pass the exams and get your certificates. Thank you. Please, I'm open to any questions that you have, if any. Thank you. Please, do you have any question? Hello?
Hello, sir.
Please, do you have any question?
Yes, I'm getting some questions in chat room.
Please, I would like you to raise your voice. I can hardly hear you.
I'm saying I'm getting some questions in chat room.
Okay, I'm listening.
He said some of the questions are in the chat room also. Kindly read, I think.
Okay. Oh, sorry. Oh, okay. Oh, okay. I'm seeing the questions. Good day, Cecilia. No, je ne comprends. This is French. My senior consul from Cameroon. Please, I don't understand. It is good. Okay, it is good now. Sorry. As you said, it is voluntary. Will there be no payment by the parties to the mediator? Yes, thank you so much. I think I forgot to mention this is a very important part of mediation. Okay, you can't go to mediation without payment. At the closing, at the introduction at the introduction and opening statement stage, that is where the mediator, as a mediator, you have to mention the amount of money you intend, okay, to charge the parties. So I don't know, the parties are going to pay. Mediation is not free. Parties pay for the mediation, and the payment, the parties still have that voluntary right to decide among themselves. Is it going to be one person going to going to take charge of the payment, or we are going to share it amongst ourselves? Okay, so that is how it is conducted. You must pay, parties must pay when they go to mediation. Yes, it's a paid situation. So the next question is, they will pay but voluntarily. Yeah, refers to their, yeah. I think somebody responded to the question. Yeah. So what happens when parties fail to reach an agreement when they were referred to? Yes. So when parties to mediation fail to come to an amicable solution, when a court refers to them, the parties or the mediator must come up with an agreement or with a final closing remarks concerning the mediation process. Okay, and serve it to the court, the judge who referred the parties to the mediation, that the mediation failed. Okay. Upon that referral, that means that it will be deemed that mediation never took place and the court proceedings proceeds. Okay, so when mediation fails, the parties still proceed with the court process. So that is how it operates. Thank you for that question too as well from Techno. I don't know, there's no name. Techno, Pascal, you've been so active here. Idoko, Selena, thank you so much for your question too as well. I think there's a different question. How are parties limited from the exposure of unskilled mediators? Yes, this one also, it has to come under the introduction and opening statement remarks. Okay, as a mediator, when you are beginning to mediate, in your introduction, you have to tell the party who you are, even in the first place, okay? Before you even introduce yourself, the parties themselves will find you. We have mediators association, we have associations for all these kind of people. So if you want to engage any mediator, you know where to go, and you know how to determine whether this person is a skilled or unskilled mediator. Okay, I don't know. They ask for the person. Are you a certified mediator from where? From which institution? All this kind of thing. That is the only way you can use to, determine some of these skilled and unskilled mediators. There's no laid down way of determining this, but it is left with you once you want the best to ask a lot of questions any person you approach, okay, to be a mediator in a particular case. You have to ask the necessary questions and see whether you are satisfied. If you are satisfied, well, you go for it. You know that this person that you've been referred to, or this person who is a mediator from ABCD is qualified or is skilled, okay, to handle our situation. So that question was from for Hilili. Sorry if I cannot pronounce your name correctly, I wish it was my country name. So we have another question from Pascal. Court proceed with, okay, you were responding to the first question that I read. So that is all. I've read all the chats. Okay, is there another thing for us to talk about? Any question? If there is no question, I think we have to bring today's section to an end. Is there another question? Hello? Okay, I think there's something in the chat box. Martin, mediation being voluntary in the sense that the parties are free to decide how to resolve their dispute. What happened in a scenario where there is a clause in a contract that states that the parties are to resolve their dispute through a mediation? Are the parties, okay, are the parties still at liberty to decide or wait? Okay, so what happens in a situation where there are a clause in the state that the parties are to resolve their dispute through mediation? Yes, thank you. I think I've addressed this concern when Pascal asked it some time ago or some minute ago. I think you already here, Martin. So let me say this once again. In a situation where that this would be the exception to maybe to some extent, okay, when it comes to you saying that it is voluntary. Now, even with this one, the general rule is that once it is provided for, it's a contract. A contract is something, an agreement between two or more parties where there are the terms, do this, do this, do this. If you refuse to do this, once you refuse to go by any of the terms of the contract, it's amount to a breach of the contract. And the breach has to come with enforcement. And the enforcement is sometimes come with a whole lot of damages. And so I'm saying that in a situation where there's a contractual clause or there's a clause in the contract, a term in the contract that says that in terms of any dispute, we must resort to mediation. That would be the first point of call. At that point in time, there's the voluntariness of the parties is missing, it's taken away. Whether to go to court or to go to mediation, at that point in time, once it is provided for in the contract, it's taken away. You only have mediation. It is only if the mediation, it is only after the mediation process have expired. Okay, that is where you have that voluntariness to initiate a different process to enforce whatsoever breach that occurred in the said contract. Okay, so that is how it is. First of all, you have to go by what the contract says before you go to any other place. Okay, yes. I hope your question is answered. Okay. So I'm so much glad, I'm so much grateful for your engagement, and I must say that there's a different question again. Okay, yes, you're welcome, Martin. I'm so much glad, I'm so much grateful for having each and every one of you here. Lawyer Charles, I've seen you, you've been throughout today's section too as well, and you're one of our most honorable facilitators. Thank you so much for the support. To our dear registrants or students who attended the school or the class today, I must say that God bless you and look forward to writing your exam soon, and you'll be given your certificate. This particular course, your certificate is going to be given free, but make sure you pass the exams. If you don't pass the exams honestly, we can't issue a certificate for you. So this is what I have to present to you, our dear cherished students, for today, and have a very good evening. Please, Lawyer Charles, do you have anything to say? Sorry.
Yes, sir, I have something to say.
Okay.
Yeah, I am Pascal. I want to just suggest something about this course. In normal circumstances, the act of mediating is not so, it is not an easy thing. We have just to make it is not an easy thing.
Okay.
Or an easy work to do.
Okay.
Okay. It's not easy work to do.
Yes.
Okay.
Then I am asking, what will happen after this course? Since we really require practical experience, can you just show us like a sketch, or we will have practical aspect of this course where we will deal with the act of making people cool down, relieving their anger, so things like that.
Okay, okay. Yes, that's thank you so much for raising this point to us. For yes, the issue of mediation, even mediation, arbitration, those kind of they are more of practical, but you cannot delve into the practical without knowing the theory. Okay, so that's why I'm very glad that you've appreciated the concept that we've spoken about for the past 1 hour, is it 30 minutes or 40 minutes ago? That if you've appreciated the concept. Now, because of how diverse we are coming from different countries, okay, and we cannot meet in person to do that. The only way we can do that is that we can, yet technology is also advancing, so we can arrange separately and do that via Zoom. Okay, so we can make a time for that. We can make an arrangement for that and do the practical aspect of mediation where we have the mediator or mediators, because there are instances we can have more than one mediator. Or we have the parties appearing before the mediator with their lawyers, or they are appearing alone, and you prepare a case. You prepare a case and give to all the parties who are going to appear before the mediator. Okay, and they will develop on the case and see how best they are going to be venting out their anger, and the mediator will try to calm them down and say that, I'm here, I've told you the ground rules already, don't shout when I'm talking, switch off your phone, all those kind of things. So thank you so much. And I think I'll sit down with my learned colleagues, okay? And we'll come up with something. So just keep on following ALSA activities and you'll be updated. Thank you.
Thank you, sir.
You're welcome. Yes, Martin, you're asking a question. If only you register the link that was sent for this particular course, okay? Or the link for the entire school. If you registered for mediation through the link, this course certificate is for free. We are just, it's a way of, letting people to creating more awareness that we need to know more when it comes to issues like this. And also to appreciate, our members, ALSA members, and people who took the step to register for the ALSA school and other courses. So that's why we're giving this certificate for free. Under normal circumstances, this is one of even the major part that we should have charged. But we care for, like, we render humanitarian services. So we decided to offer this one for free. As time go by, you may even decide to add some other courses and do it for free for people and give them the certificate. At the end of the day, you need to also enrich your CV and stand out whenever you appear before any competent authority to apply for a job or any other thing. Because ALSA is not just ALSA, it's also known in law. A lot of people, we have a lot of professors under the association, doctors and lawyers and what have you. So this particular course is going to be free. Just pass the exams. Once you pass the exams, you'll be issued a certificate for free to be sent via your email that you used to register for the course. Okay, because I don't have each and everyone's WhatsApp contact, it's to be sent via your email. So if you didn't register, but you're in this meeting, try as much as possible to contact me after this particular section. So let me resolve this once and for all. Let me see by hands who are here, but they didn't register through the link. So that I'll know. Because I know the certificate will be sent via your email. Okay. Okay, I'm not sure we have any. So in the absence of any further questions or contributions, unless somebody have anything to say.
Hello?
Lawyer Charles, I was on you before somebody came in. Please do have anything to say.
Okay, Mr. Charles, we are expecting. If not, I have something to say.
Okay. You could say, you can say whatever I want to say. Then I want to conclude. Thank you.
Okay, all right, thank you. Mr. Charles, Mr. James, thanks for the lecture so far. You've done a wonderful job, and it's very crystal clear to people on board, and I could see their chat room that they are commenting well. That's great. Okay, in addition, I just want to buttress your point to the question Mr. Techno, if I'm correct, that he asked, that the practical aspect of mediation, like what does a mediator do in a practical sense? So just to make it clearer to him and others here, what a mediator does is that happens on daily basis. Even in your house, in your family, in your friends, you see people that have issues, you step in, you look at them, you see how you can make them come to terms. So that's just what I want to add to it. So since you're a law student, you'll be mediating by one way or the other.
All right. All right. Okay. So like Mr. Kunle, please, are you done?
Yeah, okay, yeah. So I'm with you. Sorry, I just paused a while. So I just want him to have that confidence in him that what he has been doing, whenever there is issues within his vicinity, is part of a work of a mediator. But you need to scale it up to a professional level by having this course and knowing some nitty gritty about it.
Okay. Okay. That's awesome. That's awesome. Thank you so much for your contribution.
You're
That's one
welcome.
of our greatest, like one of the facilitators under the ALSA School of Legal Education. Thank you so much. Thank you so much. Please, Charles.
Sorry, Vukule, I didn't hear what you said, but in absence of that, I know you still discuss later. Actually, I appreciate anyone that came for the lecture. We really appreciate Mr. James, how calm and patiently he was in order to answer all the questions. God bless you. I don't have any other thing to say.
Oh,
Thank you.
thank you so much, Lawyer Charles, Kunle, and all our participants here. Yes, I can see the Pascal. Thank you so much too for all the great questions that you guys asked. So all of you have a very wonderful evening and good afternoon or good morning wherever you are hearing me from. So we bring today's class to an end and have a very fruitful evening from my end in Rwanda. Goodbye. See you later.